Hello, I'm Vince White. I'm an employment attorney. And yesterday we mentioned a little bit about New York City ending at will employment for fast food workers, right? And kind of some of the policy reasons why that could be good, why it could be bad, why politicians may have actually done it, what the real reason was. But that's probably not, I mean, nobody cares what we think about economics or politics. There's a good reason for that. We're lawyers. We're not politicians. We're not policy experts, and we're not economists, right? But what we are good at, I think, many other people seem to think as well, we're good at digging into how these laws give you actual practical protections, right? And so here, we can do that. We can look at what the actual standard is to terminate a fast food worker in New York City once this law goes into effect. So a lot of reporters are throwing around the term "good reason." You can't fire them without a good reason. It's a fairly useful phrase, but it's not actually the standard. The standard is just cause, and the law, which is an expansion of, and let me make sure I get the name right, an expansion of New York City's Fair Workweek law, which has other protections in it for fast food workers, including notice periods. You have to know about your schedule long enough in advance, stuff of that. Really, really good things, right? So that they're expanding that statute, and they're giving this protection. And essentially, here's how it works: once you take a job with a fast food company, fast food restaurant, and you get past your first 30 days, so you get past your probationary period, it's going to become illegal to terminate you or to reduce your hours by your regular schedule by more than 15% of your hours without what's called just cause. And they do give elements, they give factors that help people to understand what just cause is. There's a bunch of them. We're going to touch on some of the high points here. First and foremost, did the fast food employee know, or should they have known, that they were breaking the fast food restaurant's policy, rule, or practice, which is the basis of the discipline they're receiving, right? If they didn't know and they had no means to know, well, sounds like you can't really hold them accountable for that. That makes sense. That's fair, and that's also going to be kind of meaningless, because when you take a job at a fast food restaurant, they have you watch a couple of videos, they have you go through a handbook, you sign the handbook, so the knew or should have known is just going to be like, well, we told him or her to read the handbook. They signed that they did, so they must have known. The comeback to that is nobody reads that whole thing and nobody can remember that whole thing. Okay, but then the response is, but we told you to. It was actually one of the first things we ever told you to do as part of your employment. You were on the clock when you were supposed to read that handbook. What do you mean you didn't read the handbook? That's now another you're now insubordinate. You didn't do what we told you to do, right? So this factor is kind of a non-factor in reality for any major fast food restaurant. They're just going to have you read the handbook with all the rules, and they're going to say, that was in the rules. It was in the handbook. You knew, or you should have. We told you to. We told you to read. You swore here that you did. So, okay, not a useful factor, right? Whether the fast food employer provided relevant and adequate training to the fast food employee. Okay, well, that could be meaningful if judges construe a handbook and reading through a training packet to not be sufficient, right? Because it's really easy to cram all the rules, all the regulations, all the practices in the handbook. It's actually one of the amazing things that fast food restaurants do, especially the franchised ones. They create these massive handbooks that let everybody know, whether you're straight out of high school or you've been doing this for 30 years, they're going to let you know how this fast food establishment does everything. That's how they get the food to taste so similar across the nation, across the world, right? So they're very, very good at that. If a judge, or an arbitrator here, I guess, says, yeah, the handbook's not enough. It's not enough for training. You need to go further than that. Well, that's going to be really interesting, and that's going to change everything. Do I think they'll do that? Probably not. I don't think they're going to do that. I think they're going to say, yeah, you had the handbook. You knew better, or you should have. Okay, so the law in these first two factors is kind of, if I'm being honest, the law is kind of a fake law, right? These first two factors, not very useful. Number three, whether the fast food employer's policy, rule, or practice, including the utilization of progressive discipline, was reasonable and applied consistently. Ooh. Oh, this is real in two different ways. This is actually a real protection of sorts. So one, you need progressive discipline, which means if you're not engaging in a massive mistake, massive blunder, massive intentional act that's contrary to what your employer wants, you know, you're probably not going to need progressive discipline if you haul off and slug your coworker, right? But let's say you make the food wrong. And they tell you, hey, you're out of here. You're fired. Well, come on now. Seems like a teachable moment to me. Let's engage in some progressive discipline and say, hey, you're not doing that the best way. Let's watch this training or little hands-on training and get the food made the way the company likes, right? So progressive discipline is really meaningful. I think it's a good thing. You're not going to be fired for the first infraction for medium and small size issues. Now, applied consistently. You may have noticed applied consistently at the end of that factor. That's really important. Now, there's already some level of requirement that you apply discipline consistently, because if you, let's say you've got men and women working in your establishment and you're really hard on women. You just, when they make the slightest mistake, through the roof, huge problem, gonna fire you, everything. But when the guys make a mistake, well, boys will be boys. Nope, that's not gonna fly. That's gender discrimination. That's a disparate treatment claim, right? So that's not a new concept to this field. That's something that's been around for a while. Here, they seem to be taking it out of the context of discrimination. Right? If you have two people who are exactly identical in every single way, all the same protected classes, all the same faith, same race, same gender, everything. But you're really nice to one, maybe you just like them better, and you're really hard on the other. Ooh, well, we are not applying our discipline consistently, are we? And that seems to be a problem under this particular factor of the law. So there are two actual real protections in this factor, in factor 3, that mean something, that make this law more than the usual New York City fake protection for political reasons, right? And that's impressive, and it might be that I owe Brad Lander a bit of an apology, because there's actually, I found at least two actual teeth to give this some enforceable strength in this law, right? A little teeth to it. Give it some bite. To make a really strange metaphor, I guess. Number 4. Factor 4. Whether the fast food employer undertook a fair and objective investigation into the job performance or misconduct. Here's the thing. Largely meaningless, because every large fast food establishment has cameras in their kitchen. It's been that way for a long time. So all you have to do to comply with the investigation is somebody's doing something you don't like, pull the video, cut the video, save the video. Here's my investigation. Enjoy. Here's your termination, right? Not that big a deal. I mean, if they're just not producing, if they're moving a little too slow, I guess maybe the camera might not be sufficient for that. But even then, many of these establishments can look at production rates, right? They're going to know what you produce in an hour. It sounds crazy. It sounds like you're in a factory and you're producing, cogs in a machine or something like that. But yeah, that's kind of what fast food is. It's factories for food. And some of them track it very closely. So generally, I don't think this one is going to be that big a deal. Number 5, whether the fast food employee violated the policy, rule, or practice or committed the misconduct that is the basis of progressive discipline or discharge. Oh, okay. So The fifth factor is if you're actually guilty of what they're disciplining you for. I don't know if we needed guidance on that, but that makes sense, right? And I assume if you are complying with factor 4, which is you do an investigation, you're probably also coming down to whether or not this person is actually guilty or not. You're going to have some evidence one way or the other, right? So I'm not too impressed with factors 1, 2, 4, and 5, but factor 3 seems real. It's going to be a practical, real-world protection, and it matters. And that is surprising to me. It's really surprising and kind of like a nice moment. It's a really nice thing to be wrong about, that they actually did something real for employees. That's amazing. I hope that puts a smile on your face if you're working fast food these days. Closing note, don't give up on unionizing. This is not as good as being in a union. I know you may not want to pay union dues, and I know a lot of unions aren't what they used to be. I know some of them do nothing and they just take your money now. But if you can get a real effective union in place and you stay on top of it, you make it actually do its job, oh my gosh, you're going to be so much better protected in this law. This is nice. This factor 3 here is real and it's nice. But go get a union. You're going to be much better off. Bargain as a group. Good luck.